We will begin with my opening remarks. Then I'll introduce our guest, Mr. Schrader, who is here from the Office of Legal Counsel. And then he will have a chance to make his prepared statement. And then we will go ahead with questions and answers. And we perhaps will have colleagues, I don't know how many, appearing virtually since the Senate is not presently in session and essentially every colleague is away. And if so, I will obviously interrupt to recognize colleagues who persist. But let me start by thanking Ranking Member Kennedy for agreeing to hold this hearing with the Senate out of session. He is busy on the ballot shortly in Louisiana, so he has important things to do down there, and I'm grateful that he has encouraged me to go forward notwithstanding. And we will continue working together in bipartisan fashion on these issues. I want to express my appreciation also to him and to his staff for the work that has gone into a bipartisan report from the subcommittee on executive privilege that this hearing and the previous hearing will help inform. So again, appreciation there. As I mentioned, this is our second hearing related to the oversight logjam between Congress and the executive branch. In recent years, it has become harder and harder to get meaningful answers from the executive branch. Last August, in the first hearing, we heard from experts about executive privilege problems driving this gridlock and how we can fix it. We found clear bipartisan agreement on a few points. First, since the dawn of the Republic, the executive and legislative branches have worked in good faith to negotiate solutions in oversight and information disputes. Executive compliance with this so-called accommodation process has been governed for years by a Reagan-era presidential memorandum. That memo set out a substantive standard that the executive should comply with congressional requests for information to the fullest extent, and that the president should assert executive privilege only in the most compelling circumstances. The memo also set out a process for making those executive privilege assertions. It assigns the Department of Justice, through the Office of Legal Counsel, the role, I would say, as an ombudsman, to balance meeting Congress's information needs to the fullest extent against the executive's interest in confidentiality in compelling circumstances. Both this balance and this process have completely broken down in recent years. Administrations of both parties have steadily expanded the scope of information withheld from Congress on executive privilege grounds and the circumstances under which the executive branch withholds it. Far from treating executive privilege as a last resort triggered by an assertion by the president himself, executive branch officials routinely withhold information without any formal assertion of privilege ever occurring. Compounding these problems is OLC's reliance on extreme separation of powers theories that bear on the executive privilege question. One example is absolute immunity, the notion that Whitehouse officials can ignore congressional subpoenas because they are absolutely immune from ever testifying before Congress. That theory has no support in judicial precedent. Indeed, it has been outright rejected by federal judges appointed by presidents of both parties, including now Supreme Court Justice Ketanji Brown Jackson as a district court judge. But it lives on in a parallel universe over at OLC, and a private one at that, as OLC opinions are often kept secret from Congress and the public. OLC does seem to disregard these determinations by Article III courts of what the law is. The second point of agreement we found was that Congress needs to step up. When the executive branch controls the information sought, the documents are in their care, and the doctrine applied through OLC opinions, and the process followed, Congress must look elsewhere than the executive for tools to overcome executive blockades. To restore the Reagan memo's balance and process, we will need to rethink how Congress can revitalize its role. The Office of Legal Counsel is the driving force in the executive branch on questions of executive privilege and separation of powers. That's why I'm pleased to have Assistant Attorney General Chris Schrader with us today. To my knowledge, Mr. Schrader is the first sitting Senate-confirmed head of OLC to appear before Congress since Jay Bybee testified 20 years ago. It's been a long break, Mr. Schrader. And the first sitting OLC official to appear since 2010. Getting this accomplished took 10 months of negotiations, and I want to say a word of applause to my staff for their persistence in this endeavor. But it was vital for us to understand OLC's perspective on executive privilege and the accommodation process given its central role. So here's what we face. If the Office of Legal Counsel resumes the role of ombudsman, if the Office of Legal Counsel meets Congress's need for information to the fullest extent, if it limits executive privilege assertions to actual assertions in compelling circumstances, and if it restores the process of the Reagan memo, that creates a very different terrain than we now inhabit for Congress to navigate in undoing the information blockade. So we need to know which way OLC is going. Getting Assistant Attorney General Schrader here required a few accommodations from us. We agreed to focus on OLC's role in questions of executive privilege and separation of powers. We will not be discussing any matters related to ongoing litigation or January 6th or outstanding oversight requests to the Department of Justice outside of those to OLC itself, should they arise. We need to fix this mess, Mr. Schrader, and the baseline for that repair will be clarifying how the executive branch will respond to information requests from Congress. If it is to return to the Reagan memo, we must understand how and when that change will come, where we go when we feel we are being thwarted, and what assurances from the executive Congress can have any reliance on into the future. I look forward to you shining some light on these issues. Bitter experience has brought us to this day. Let us hope this hearing is a turning point. Thank you, sir, and you are recognized for your statement. I should add that Mr. Senator Kennedy is more than welcome to offer an opening statement to the record for this proceeding at his leisure. The record will remain open for a week at the end of this for that statement to be added if you should so choose. Mr. Schrader.
Thank you, Mr. Chairman, and Ranking Member Kennedy and the other members of the subcommittee. I appreciate the opportunity to appear here today and appreciate the accommodations that have been extended to me. I think we first negotiated my appearance when I was having a hip operation, and I have thoroughly recovered from that, and I'm delighted to be here today. You have my written testimony. I'd like to make just a few opening remarks. At the outset, I want to affirm the great importance of Congress having the information that it needs to conduct its work. To acquire that information, Congress's power of inquiry is expansive, but it does have some limits. In particular, the executive branch has confidentiality interests that can argue against disclosure, and Congress's needs should be assessed against those interests. In the words of the Nixon tapes case, such confidentiality is, quote, fundamental to the operation of government, close quote. Presidents throughout our country's history, beginning with George Washington, have relied upon this power to protect the executive branch's functioning and the public interest. When Congress requests information from the executive branch, Of course, the two branches can sometimes disagree about what information should be provided. Even so, as the Supreme Court recently noted in the Mazars case, throughout our country's history, the two branches have developed practices to navigate this rivalry through good faith reciprocal consideration of the other branch's interests. As I have said, the executive branch acknowledges the legitimate needs of Congress for executive branch information, and it should never simply disregard those requests. Instead, as the D.C. Circuit wrote in 1977, quote, each branch should take cognizance of an implicit constitutional mandate to seek optimal accommodation through realistic evaluation of the needs of the conflicting branches in the particular fact situation, end quote. What the D.C. Circuit also noted in 1977 remains true today. This constitutionally mandated accommodation process very often results in an acceptable resolution of initial disagreements. The 1982 Reagan Memorandum, which you mentioned in your opening remarks and was discussed at your last hearing, outlines the executive branch's approach to this accommodation process. It directs agencies to, quote, comply with congressional requests for information to the fullest extent consistent with the constitutional and statutory obligations of the executive branch, making a good faith attempt to accommodate Congress's requests for information. Likewise, Congress is obliged to make good faith attempts to accommodate the executive branch's confidentiality interests and other interests when requesting that information. Let me just conclude by outlining the role of the Office of Legal Counsel with respect to the accommodation process. First, OLC provides informal counseling to agencies about Congress's oversight authority and executive branch positions and institutional interests. However, OLC does not monitor incoming congressional requests or the executive branch's responses, nor does the office participate in the negotiations between committees and agencies during the accommodation process, or act as a referee between them during that process. Second, in those rare cases where the accommodation process breaks down and the agency is considering whether to request the president to assert executive privilege, OLC participates in deliberations with the agency and the White House counsel's office about the potential need and basis for a presidential assertion, as described in the numbered paragraphs of the Reagan Memorandum. If a decision is made to request such an assertion, OLC will prepare an Attorney General opinion to the President stating and setting forth the legal basis for the President's possible assertion. Third and last, on relatively rare occasions, OLC is asked to address a novel legal question that arises following a congressional request for information. Also, OLC has issued a small number of general guidance documents in a freestanding opinion about oversight or executive privilege that is not tied to a particular oversight dispute. Thank you for the opportunity to discuss these important issues. I look forward to answering any questions that you may have.
Thank you. I look forward to our conversation as well. I'd open, I think this is probably not the only point of disagreement that we will have, but you, in your statement just now, indicated that it was after the accommodations process had broken down that the process of considering a presidential assertion of executive privilege would begin. I'm not sure that's actually the way the Reagan memo requires. I think that you could move forward the presidential assertion quite a lot and then have a process of accommodation once the assertion has been made, because the Reagan memo contemplates that even where there is a potential grounds for asserting executive privilege, it can readily be waived for all sorts of reasons in the process of accommodation. So moving that assertion to the tail end of the process, I think, is a judgment call that may not be one that we agree with. It is not one I agree with, I'll say that much. So I want to talk about four things: doctrine, balance, process, and trust. Let's start with doctrine, because in this area, I believe OLC sets it for the executive branch through its opinions. Is that correct, Mr. Schrader? Your OLC opinions are enforceable throughout the executive branch, and yours are authoritative within the executive branch in this area?
Yes, Senator, that's generally the case. When the Office of Legal Counsel issues a legal opinion on a matter of law, it has a binding effect in the executive branch.
So the first concern that we have is that if the doctrine is very extreme, it creates a platform that makes it very difficult for the accommodation process to be pursued. And when I say extreme, I mean extreme in the sense of putting the executive priorities at the forefront and outweighing congressional priorities in the analysis. And an example that I would give you is the question of absolute immunity. I think you'll concede that absolute immunity bears somewhat on the question of executive privilege. It both has to do with congressional search for information. It's both are informed by separation of powers. They are in many respects parallel issues, are they not?
Well, Senator, let me say at first that I'm entirely agreeing with you that it's important for this process to work properly. In my experience and the experience of OLC leaders that I'm familiar with, there's not an effort in the accommodation process from our perspective to prioritize executive prerogatives. What the accommodation process requires is the good faith accommodation of Congress's interest by the executive branch.
Yeah, well, I'm still on the subject of doctrine. I haven't gotten onto the accommodations process yet, because it's OLC doctrine that informs the executive branch's position in this area, correct?
It is. And
so if you have opinions that bear on this question, those opinions are the platform off of which executive decisions about accommodations will be based, correct?
I agree with that as well, yes.
And absolute immunity is a doctrine that is not unrelated to executive privilege. So to use it as an example is perhaps not out of bounds.
I agree with you as well. It's an example that arises in a minuscule number of oversight controversies. It only applies to immediate advisors of the president.
Yeah.
The vast, overwhelming majority of congressional requests for information do not implicate live testimony by an immediate advisor of the president.
Correct. But here's my point, which is different than that. My point is that the issue of absolute immunity has been addressed with considerable judicial skepticism, shall we say. Now Justice Ketanji Brown Jackson, in the Magan case as a district court judge, talked about the assertions by OLC of absolute immunity, and she said two things that I thought were noteworthy. First, and I'm quoting her here, the arguments the DOJ advances to support its claim of absolute testimonial immunity for senior-level presidential aides transgress core constitutional truths, paren, notwithstanding OLC's persistent heralding of these and similar propositions, close paren, close quote. And she also says the absolute testimonial immunity for senior-level White House aides appears to be a fiction that has been fastidiously maintained over time through the force of sheer repetition in OLC opinions. So I think you'll concede, I guess let me ask you a question. Has OLC rewritten any of its guidance about absolute immunity since that decision? Did that cause a review of the previous OLC opinions to adjust for what the Article 3 judge had to say.
Well, Senator, what I can say about that is I'm not at liberty to discuss what we are considering or not considering before an opinion is issued.
But it hasn't been done yet.
I want to add that when I testified before this committee and during my confirmation hearings, I stated that I had no agenda to reconsider prior OLC opinions. As you can imagine, we get frequent requests to do that. We won't simply take up prior opinions and review them spontaneously. If they are implicated in a question that we are being asked, and we have not been asked a question about immunity of immediate advisors, unless the president directs us or the attorney general does, we would not initiate a spontaneous review of any opinion of the office.
So there's the problem that we face on the question of doctrine, which is that OLC continues to maintain in its opinions statements of doctrine that have been very firmly, I think that's, you'll agree that that's some pretty strong judicial language used by District Judge Jackson.
It was strong language, and other opinions have been equally strong. There have been developments in this area in the judiciary since OLC has offered opinions or the department has litigated this position in court. Of course, if it arises again, and I must just say parenthetically, this is a very rare occurrence that doesn't affect 99.9% of the accommodation processes and congressional requests that the executive branch sees. But if it does arise, there are processes in the Justice Department that will review those kinds of doctrines before we submit a brief on the matter.
So my point is a fairly simple one. If people are looking at OLC opinions as the basis for determining where the accommodations process should lead and how it should be pursued, there is a clear discrepancy right now, at least in the absolute immunity area, between what courts say and what the existing body of OLC opinion says. And when OLC does not adjust for those judicial opinions, it creates, I think, a real hazard that in other areas of congressional executive balance or dispute, that it gets a little hard to believe that the OLC will be a fair adjudicator of the legal principles. It really does seem a little bit as if OLC is maintaining its own jurisprudence outside of and separate from Article 3 jurisprudence in these areas.
So, Mr. Chairman, I appreciate what you're saying. I get the point. I do not, however, believe that the opinions we have issued on, the office has issued in the past on absolute immunity impacts the doctrine relating to the Reagan Memorandum or the assertion of executive privilege in the course of the normal kinds of oversight requests that we receive, which are predominantly document requests or testimony by agency or department officials. And I hope people will not draw the conclusion on the basis of their disagreeing with what is currently on the books with respect to absolute immunity by the Office of Legal Counsel, that those subjects are affected by those, what is really a discrete issue about the access to immediate advisors of the president that doesn't affect the overwhelming number of oversight requests.
Agreed, but what's clear in that example is that OLC's, if you don't mind my using the word jurisprudence, varies significantly from Article 3 jurisprudence and has not been adjusted for the Article 3 jurisprudence that has emerged. And that, I think, creates a difficulty. If that's the only place where that happened, then I take your point. But if the underlying principle of OLC is that it feels that its jurisprudence withstands effectively being overturned by Article III district court judges, then it's hard to understand why that principle of independent OLC jurisprudence would not also pertain outside of absolute immunity in areas that are very, very closely related involving executive privilege. You see my point?
I do. I do indeed, Mr. Chairman.
So let's go on to the balance question. Our experience, first of all, let me just put into the record the McGahn decision. Since I've mentioned it, it's a matter of record. And because we've talked about some of the OLC opinions, I will also put into the record a recent Lawfare article called Previously Undisclosed OLC Opinions Illuminate the Growth of Executive Power, written by Jonathan Schaub, who is, in addition to other things, an alumni of OLC and a very well-regarded lawyer. So on the balance, you've heard my concerns that when the same group is entrusted with balance, that is entrusted with balance is also doctrinally in what seems to be a far corner. That is supported by our experience of non-assertion assertions, and I'd offer again into the record a transcript of a conversation I had with then Attorney General Sessions regarding his assertion to the Committee of Executive Privilege, which never yielded an actual assertion by the President of executive privilege. It was an abeyance, I think was the word he used, during which time no information would be provided and none ultimately was. And yet, at the end of the day, there was no assertion of executive privilege. We've also seen huge, enormous document productions of blank pages with the word constitutional privilege stamped on them. Don't know quite what that meant. We are right now unable to get oversight materials related to a matter within the Antitrust Division of the Department of Justice because of an ongoing Inspector General investigation, but nobody has explained why an ongoing Inspector General investigation would prevent Congress's oversight, particularly in the era of the copy machine, and a process of accommodation you'd think there could be pretty easily worked out as to how the two investigations would proceed side by side, but that's not what's happened. And this is within the Department of Justice. They've just said, no, you're not going to get them. And we're still pursuing that. So the practical experience we have is that the balance is not respected in the executive branch. And as a result of that, the process is somewhat broken down. I'd throw in that there have been a few other sort of Phillips added that make it more difficult, like a doctrine that only chairmen can get requests for information answered, which I think has appeared in executive defenses against congressional information requests, and also the theory that in a new Congress, all pending information requests that have not been answered are erased and have to be started all over again. So when you see that array of obstacles, again, it's hard to have confidence in the balance, which then takes us to the process. We've done research, and we believe that in the past 14 years, which have been characterized by fairly constant back and forth between executive and legislative branches over information, there have been exactly 2 assertions of executive privilege. One by President Trump related to some census documents, one by President Obama related to Fast and Furious. So this goes a little bit back to the first point. Where that assertion gets made in the time sequence has a lot to do with the validity and availability of the process. And it really seems that if it's only happened twice in 14 years, when you consider all the information that has not been provided in that period, that something has broken down quite a lot. You'd think you might actually add a 0 to that number and make it 20, or perhaps even 2 zeros and make it 200 if the process were actually vibrant and operating pursuant to the Reagan memo. And Mr. Schroeder, you just mentioned one of the concerns that we have about this when you said that you do not act as a referee and you traditionally stay out of a lot of these determinations. And the question there is, if you're being stonewalled as a member of Congress by particularly non-assertion assertions of executive privilege, where do you go? Where do you go to trigger the accommodations process in the executive branch? Now, presumably, OLC would have a role because you'd be the guardians of the propriety of the process. You'd be the, I keep using the word ombudsman, and you may object to that. You use the word referee, but you're, in theory, operating in these disputes as something more than the advocate for the executive branch. Is that your understanding of your role?
Yes, sir. That's my understanding.
Yeah. So how do we get to you if you don't act as a referee and if you're not involved, to follow your own statement, in the disputes? It seems like it's hard to have a process of accommodation work out if there is not a referee, particularly when one side is sitting on the documents and could just say no. How do we get you involved? How do we get a forum to make the case that documents are being unreasonably withheld?
Well, Mr. Chairman, our normal interaction with agencies and departments brings us at least to some level into the process, because when a committee or subcommittee is having a disagreement with an agency, that agency will reach out to us for advice about how to meet the disagreement between the two institutions. And we will offer counseling advice about ways to provide information that doesn't jeopardize the stated confidentiality needs of the agency. We will also discuss with the agency or the department the nature of those interests and see if they are actually the kinds of interests that outweigh the agency's understanding of the needs of the Congress. So we are participating in that conversation, trying to provide, and I think are providing, impartial advice about the need for the executive branch to respond in good faith to the requests of the Congress.
Can you describe for me, because I'm not in that process at all, a little bit more practically how that works? I know that from my days in the department, there's an awful lot of process and procedure to guide the way the department conducts itself. What is the procedure that takes place between an agency and OLC about when the agency is supposed to notify OLC about a contentious request? When does OLC... You follow my question? I don't need to go down the road too far if you already know what I'm getting at.
I do understand.
So what does that look like? Is that written someplace? Is there a policy manual, or is there guidance, or is
So we have emphasized, and Whitehouse Counsel has emphasized in meetings with General Counsel, that if other agencies and departments have issues that they see arising in an oversight situation, the Office of Legal Counsel is available to provide counseling and advice. And we have some very senior career employees who have colloquially gone around the block a couple of times on these issues. They understand practices. They understand the different complexities of responding to Congress. We don't have a trigger mechanism that requires the general counsel of a department or an agency to reach out to us. But our experience has been when a oversight request becomes contentious, it's quite often, I think probably overwhelmingly the case, that general counsel will want advice, and they reach out to the Office of Legal Counsel. That could be just informal as a phone call.
Yeah.
It could generate a little email traffic. Most often in my experience during the time that I've been at OLC, it's a couple of phone calls and perhaps an email memorializing some of the advice that we have given.
And presumably when that takes place, there's a file someplace in DOJ that memorializes that exchange and preserves records of whatever conversations or memoranda took place.
Yes, Mr. Chairman. I mean, as you're aware, they're federal records,
Yeah.
and we
And they
retain
would
those
be
records.
filed sort of by question or by dispute, if you will.
Quite often. Sometimes they will just reside for a while in our email files, but eventually they will be memorialized in a file memo or something similar.
Yeah. Well, if there is some memorialization of how this works that you would be willing to share with us, I know that's going to take some consideration, so I'm not asking you to say yes or no today, but I would ask you to take the question back about what documents you can provide us that demonstrate that process as it goes forward, because we have no visibility whatsoever into it from the congressional branch, and yet we're being asked to rely on it as a fair and fairly neutral ally is not the right word, forum.
Mm-hmm. Well, if we could just perhaps engage in a little on-the-spot accommodation conversation, I think it would be easier for me to anticipate our ability to provide you a summary than it would be the raw documents. So if you would be willing to accept that as a first step, I think we could put together a summary of how we proceed.
Yeah. What we're trying to do is to figure out how it is that we're not just up against an absolute wall of executive indifference and executive-leaning doctrine and failed process, because that's our experience from our side of the exchange and over many years. Again, that's my observation, and it has elements of opinion and anecdote to it. But when you look across 14 years and find that only 2 actual assertions of executive privilege were ever made, that seems to me a pretty strong sign that something has broken down, and that the determination whether executive privilege belongs or not failed to be achieved in a great number of circumstances.
So, Mr. Chairman, if I could just reply briefly to that?
Of course, that's what you're here for. That's what I'm here for.
It is a possibility that the rarity of executive privilege assertions may demonstrate that the process is working satisfactorily in a wide number of situations that don't make the news because the contentious ones dominate the news cycle. A lot of committees and subcommittees in the House and the Senate have conducted oversight over the years that don't result in impasses at the end. Quite the opposite, I think. I think it's skewed way in the other direction. So the number of cases in which a subpoena has been issued and a contempt vote scheduled, which is under our current practice and the consistent interpretation, our interpretation of the memorandum, the Reagan memorandum, is the stage at which the president would consider assertion of executive privilege. So those don't arise very often. And I think one of the reasons, it may not be the only reason, but one reason is that the accommodation process works in a vast majority of situations. I had acknowledged that there are impasses. There are situations in which
We've lived through a great many of them.
Yes. I can't speak to any particular situation that you've described. I'm not familiar with the facts, for one thing. But I think in the mine run of situations, I have a different impression about the ability of Congress to get the information that it needs to do its work.
So let me try to clarify what you meant when you said, I think I'm quoting you correctly, that OLC does not act as a referee. I assume that by saying that, you meant that in these early stages of the conflict or dispute developing, OLC is not engaged as a referee. I'm putting words in your mouth right now, so you'll have a chance to correct me if I'm wrong. But that when it does rise to the level of requiring OLC attention, OLC takes the position that it has a role that is not just the advocate for the executive branch, but is a referee or ombudsman type role to try to protect and preserve lasting principles of inter-branch comity.
Yes, I think that's a fair statement. We don't call balls and strikes between the agency and Congress unless the department or agency is making a mistake of law. If they are resting on a position that we don't think is justified, we'll tell them to stop doing that.
Yeah, well, that I'm sorry to go back and dwell on this again, but if I'm agency counsel for agency X and I'm asserting, let's say, absolute immunity for my secretary regarding meetings held in the White House, and you come in as OLC and say, you know, I think you're wrong here as a matter of law and you need to adjust your position. And then agency counsel says to you, no, we're not wrong. We're following this OLC opinion, which fails to contemplate Judge, now Justice Jackson's decision. So that's how this separate OLC freestanding jurisprudence, I think, can infect the accommodations process, and why I'd ask you to reconsider when a judge basically throws out an OLC opinion, the OLC process of letting it continue to stand. The last point, I guess, is going to be about trust, and I don't mean that in terms of personal trust. I have the highest regard for you. And as a former Department of Justice lawyer, I think the Department of Justice lawyers are far more trustworthy than the average person. But institutionally, we in Congress have to put an awful lot of reliance on how the executive branch and OLC will interpret things. And as you know, these things are most contentious where the investigation is into executive wrongdoing. You agree with, let me ask you a legal proposition. Where Congress is pursuing executive wrongdoing, executive privilege is on its weakest footing, correct?
I think that's yes, I think that's an accurate general statement, yes.
And yet from a practical and political standpoint, that's also the point at which the executive branch has the least interest in turning over documents and evidence.
Now you're asking me a question of human nature. As an observer of human nature, I suppose I will agree with you as well.
Yeah. So given those parameters that we're in, is there any way that OLC or the Department of Justice or the executive branch can establish guardrails that Congress can rely on so that good faith and proper accommodation in one administration are not subverted without consequence by bad faith and obstruction in a following administration, leaving us at the mercy of the tenor of the administration? And you can take that as a question for the record as well, because I think it asks for things that may take a little bit of institutional research and thought. But is there any way that we can actually rely on whatever determinations or conclusions might be reached between us about the accommodations process going forward?
Mr. Chairman, I agree with you entirely that Congress is entitled to honest interpretations of the law by the executive branch. I think this president is dedicated to that proposition. He issued a day one executive order affirming the independence of the Justice Department. And certainly the Attorney General has stated the law should be applied without fear or favor or political influence of any kind. I took this job at OLC under the same expectation. I think, I know statements, talk is cheap. I understand that, but I think I am confident this department is dedicated to that proposition, and it would apply its honest opinions about the legal requirements of executive privilege when it could be overborne by an outstanding congressional interest in an honest and trustworthy way.
Well, both you and the president have spent time on this side of the dais between us, so I appreciate your sensitivity to that. Senator Coons of Delaware has joined us, and I would now turn to him to ask his questions. Senator Coons, are you with us?
I am. Thank you, Chairman Whitehouse. I apologize that I'm in downstate Delaware and the connectivity is particularly bad. I was trying to join unsuccessfully repeatedly by WebEx. I hope you can hear me by cell phone.
We hear you well.
Well, thank you. And also I'll thank the ranking member for joining you and holding this hearing. Assistant AG Schrader, it's good to talk with you again. Thank you for your participation in this hearing. And, you know, for what I think is an important conversation, one that to, you know, one that to everyday Americans may seem like an abstract set of issues, but transparency and accountability go really to the very heart of checks and balances and our democratic system. And in the last Congress, over the last couple of years, frankly, both on the Foreign Relations Committee and on the Judiciary Committee, I've repeatedly been deeply frustrated when we had important subject matters that we were not able to get witnesses or answers to questions for the record. And so more broadly, over several administrations, I think a real and a legitimate question is how we can strike the right balance between checking executive overreach in terms of using the idea of executive privilege to shut down all oversight or inquiry, while also making sure we respect the need for the president to get confidential advice and to be able to act effectively in the best interests of the American people. And, you know, look, as with so many other things that are critical parts of our democratic system, it relies on good faith. It relies on Congress asking oversight questions and seeking witnesses in good faith and not being overly burdensome. But it also relies on the executive branch and on the administration, and in particular OLC, to follow precedent and to interpret and apply the concept of privilege in a reasonable way. So if first, and you may have already covered this, Senator Whitehouse, but I appreciate your tolerating my joining a little late given my schedule in Delaware today. Mr. Schrader, an issue implicated in any discussion about executive privilege is OLC opinion. OLC, as you know, delivers critical advice to the department and develops precedent that sometimes is not known to Congress or to the public, and so isn't subject to public scrutiny, review, or appeal. And I recognize there are good reasons for OLC opinions to be confidential for a certain period of time or in certain context. I appreciate how the Biden administration OLC has taken some key steps to restore transparency, including through reinstating the 2010 Best Practices Memo. Can you just say a bit more about your efforts to promote transparency whether you view transparency as important and why, and what opportunity you think there is to make OLC historical opinions from previous administrations publicly available so that we understand some of the self-imposed restraints the administration is operating under in terms of your predecessor guidance.
Well, thank you for that question, Senator Coons. It's good to talk to you again. I agree with you entirely about the importance of transparency. I think that the record of this administration in living up to the presumption in the 2010 Best Practices memo that signed advice, signed opinions will be made available promptly has been pretty good. We continue to strive to make sure that unless there is a particularly significant reason, and there can be on some situations, to keep something unpublished, that our clients, when they ask questions of us and want a written opinion from us, understand from the get-go that our presumption is that that opinion will be published. We've also taken steps, as you've noted, to continue to do archival work to make historical opinions of the office that were unpublished made available. And I just got a note from our main attorney advisor in charge of that project this morning that he has posted a very comprehensive index of past opinions running from, I think, 1945 to 1994, and a lot of them that are not in our bound volumes are now available in our FOIA reading room on our website. So we continue to try to live up to the injunction of the President, the AG, and the Best Practices memo to make signed opinions available to the public.
Senator Coons, did we lose you? There.
No, you did not. Sorry, I just put my phone on mute so you wouldn't hear background noise in the car I'm in. Well, Mr. Schrader, I particularly appreciate that work on making publicly available an index of older OLC opinions, which allows Congress and the public to at least know the universe of opinions of a certain vintage that you may be relying on, which then allows the public or Congress or others to pursue particular opinions if they have grounds to do so. What are the limitations and advantages of that as a way forward on transparency? And could you speak a little bit more to why transparency is a value the administration is willing to stand up for, even when it is, frankly, politically not always in your best interest?
Well, thank you, Senator, for that question. I think the certainly a major reason to emphasize transparency is that when OLC issues controlling legal advice that an agency or department acts on, the country, the Congress, the general public is entitled to know the legal basis of those actions. And to the extent that is relying upon an OLC opinion, the best evidence of our reasoning is to make the opinion available so people can look at it and criticize it if they want to, and try to understand its merits when they can. I think in general, that's a good operating practice when OLC issues advice, to make it available to the public so that the public can be confident that the administration has seriously considered the legal permissibility of what it does.
Senator Whitehouse, could I ask two more questions quickly?
Of course. I think it's just the two of us, and Mr. Schrader probably
Oh,
budgeted
good.
more time than the two of us are likely to take. So
Got it.
he's not shaking his head. So
I'm
please
not running
proceed.
away.
So the general framing of this hearing just, is a balancing act of the concern that the executive branch has a strong structural incentive to take an expansive view of privilege, and that certainly the previous administration undertook actions that were predicated on a wildly expansive view of executive privilege, and the tools that Congress has at its disposal to defend its prerogatives in terms of litigating subpoenas or specific instances of an assertion of privilege are ill-suited for the task. The January 6th, for example, and other hearings and proceedings discovered that the judicial resolution of these disputes can be very slow. I'd just be interested in your thoughts about whether a legislated solution that offers a more predictable, balanced, or rapid judicial involvement, a process by which a dispute between the branches about the scope of privilege could be resolved, is a positive path forward. What's your reaction to that as an approach?
Well, thanks again, Senator Coons. I think I would say I'm certainly in sympathy with the views that you and Senator Whitehouse have expressed about the frustrations of the congressional process when committees that requested information cannot get information as promptly as they want to. I remember my experience when I was with the Judiciary Committee, being frustrated several times in that regard, actually with respect to the Justice Department, as a matter of fact. Having said that, it's a difficult problem for me to understand that the judiciary will play a very dominant role in this process. They certainly have taken some cases over the years, but the general tenor of the opinions in this area demonstrate their deep reluctance to become a mediator between the Congress and the executive branch in this area. I think there are steps that could be taken on the congressional side to make oversight requests more focused. Sometimes requests are given that generate as many as 1 million responsive documents. That just takes an enormous amount of time for an agency to review. They have to look at them essentially one by one to determine whether there's any objection to turning them over. They end up perhaps often sending a lot of them forward, but it takes a lot of time if the requests are that broad. The D.C. Circuit said early on, and I think the Supreme Court has affirmed this, that this is one of the areas of our separation of powers that the Constitution has left pretty well up to the good faith negotiations of the two branches. And it's important for both branches to take their obligations seriously. I have no doubt that there have been periods in our history where one or the other side of the conversation has not held up its end of the conversation to get to a resolution. I hope that's not the experience of this administration. And in my time in the office, it's not. That is not my experience. Quite the opposite.
Well, if I could, and I'll follow up on that. Look, the process of confirmation of ambassadorial nominees, judicial nominees, is also one that has historically relied upon a good faith recognition on the part of Congress that the president is entitled to his nominees within reason, and that we have, for example, the practice of putting holds on nominations. And I have seen in recent months truly expansive and unreasonable holds placed on hundreds of nominations in order to either, do political combat with the administration or to try and extract some significant concessions. And so I would agree with you that there is an obligation of reasonableness on both sides. And so, this is a hearing focused on the executive branch's actions, the executive branch's assertion of a privilege and the role OLC plays in that. But I do think Congress has a role to play by pursuing information in good faith and crafting reasonable oversight requests and not intentionally, tying the hands of the administration in terms of its ability to get anything done in the best interest of the country. Do you have any suggestions about congressional best practices as a former Senate staffer that we can follow that would facilitate the free flow of necessary information for oversight while avoiding, counterproductive, unnecessary fights over privilege? How do we do a better job of doing our side of this bargain?
Well, thank you for that question too, Senator Coons. It's a little difficult to lay out a template in the abstract because the requests are so individualized. I'll offer a couple of general thoughts. One is that I think the more focused in terms of, take emails, for instance. The more focused that a set of email inquiries can be on a few individuals at the outset, instead of a kind of omnibus solicitation of all emails relevant to X subject. Those are the kinds of requests that generate this enormous volume of potentially responsive emails. One's more focused on a couple of custodians of record, individual email accounts, individuals that are known by the committee to be perhaps involved in the situation, would make the request more focused and therefore more simple to reply to and more promptly to reply to by the department. And then, of course, you could review the product of that initial kind of inquiry and decide to widen the lens to other individuals as required. That's one simple suggestion that I think would place the onus on the department to be responsive more promptly because the initial request would have been more manageable. There are other devices, I think, related to the willingness to accept something less than the complete availability of the documents initially, perhaps some more willingness to look at documents in camera or in other, and accept briefings as responses, which the executive branch does offer. But sometimes those disagreements about what the form of production should be also become fairly protracted. I'm not suggesting any of these things are a panacea, but I think they might streamline some oversight requests that can arise.
Well, I appreciate that, and I think Senator Whitehouse and Senator Kennedy are pushing on an open door in terms of encouraging the other members of the Judiciary Committee to work together to try and find an appropriate path forward that allows us to find a balance so that we can get prompt and thorough responses to reasonable and reasonably targeted and reasonably necessary oversight requests. It is frustrating to get stonewalled by several administrations on related or similar issues. I also recognize that we have an obligation to not prevent the executive branch from operating and to be reasonably respectful of the burdens and obligations of the executive branch. So thank you for your testimony today. I'm sorry I wasn't able to make the video side of this work, but I appreciate your chairing this hearing, and I look forward to working with you on the path forward.
Thank you, Senator Coons. Looking forward to working with you. Best wishes in your travels in Delaware. Mr. Schroeder, thank you very much for being here. I think we've reach the logical conclusion of our conversation at this point. Our process is that Senator Kennedy and I are going to review a report that the subcommittee could prepare and propose to the full committee. When we have bipartisan agreement on that, I'm sure we'll share it with you so that you can offer whatever comment you wish. The intention of it is not just to be a report that goes to a shelf to gather dust with other reports in the dust-gathering shelves of Congress, but to be a basis for formulating legislation that creates a process upon which both parties can rely that is much more efficient, that leads to quicker accommodations. And I think I've said it before, so I don't think I'm giving away any secrets when I say it here, but as somebody who practiced law for a bit, I always found that conferences with the court before a trial or before a motion hearing could be very instructive, and magistrates handling those conferences could be very instructive. A lawyer who was asked by a magistrate, "You don't seriously intend to bring up that argument before the judge, do you?" Or, "If you try to raise that as a factual assertion, I'm afraid you're going to have heavy sledding because it does not appear to be supported by the evidence." Those sorts of things can help sharpen the mind quite a lot and narrow the arguments and provoke settlements. And I think something like that, where we have a chance to have some entity perform that role at some point, is the direction that I'm looking for. I found those experiences very fruitful in terms of preparing for trial and motion practice in courtrooms. People talk big, and they've got their own theory of the case. But as I say, everybody's got their theory of the fight until they get punched in the face. And then suddenly you have to figure out in real life how you solve this problem. So thank you for being here. Thank you for your work at the Department of Justice. And if anybody has further information they'd like to provide to the hearing, the record will remain open for a week. And I wish you well, and I hope that it's less than 20 years before an assistant attorney general in your position appears before this committee for something other than a nominations hearing.
Well, thank you for your courtesy, Mr. Chairman. I know we haven't seen eye to eye on everything, but I think we agree that this is an important topic. If there are improvements to be made, the department will review anything that in the legislative arena that you want to propose and provide you our considered views that you can take into account going forward. And if we can continue the conversation in any way, I would be happy to do that with you.
Good. Well, we look forward to that. The conversation will continue. And the one question for the record, I think, that is outstanding out there that I'd like to have an answer for in the time frame of responsiveness to this hearing is the question of whether there are any guardrails that could give us more assurance that one administration's view of this is not readily and immediately supplantable by another administration that, for a whole variety of reasons, which could include that the congressional oversight is looking at administration malfeasance, simply does not want to abide by. If it's just jump ball every time, then we're in a very different world than if there's some real guardrails around DOJ or around OLC. So with that, the hearing is adjourned, and I thank you again, sir.